Hello, my true crime lovelies. How are you? Long time no see. Yes, I'm alive. I'm alive and well. And I have a Lori Vallow Daybell update for you today. She was in court. Surprisingly, she uttered the words "my husband" three times during this pretrial conference. Not one of those times was she referring to Chad. What am I talking about? Well, let me get the intro going and we'll get into it. All righty. The last time we spoke, there was another pretrial conference. We talked about things. I've got notes again. The questionnaire for the jury members and how the court was going to use Lori's name in the questionnaires. We talked about Alex's statement being hearsay, Lori giving a couple of different hearsay exceptions that the judge shot down, Speedy trial we talked about. So all of those things came up again in this hearing. It's interesting though. First off, I want to say neither Lori nor the state, the prosecutor, are likable. I don't know if the prosecutor is like being bitchy because it's Lori, but hopefully she'll be able to turn on the charm when the jury is seated or before when they're doing voir dire, right? Okay, and also this time, excuse me, last time I just did a recap and I played the video in the background. That was the first time I tried it. I am going to split the baby. I'm going to give you this recap with just me and no video, and then we're going to look at the video together. That way, if you've already seen the video, you don't have to stick around for the second half of it. I mean, I'll be giving commentary on it, but if you just want my 2 cents off the bat, the first half is for you. Okay. So they talked again about the jury questionnaires. The 200 are going out via e-survey. This time, the prosecution was asking if they could include JJ and Tylee's name since we're including Lori's. That way, if anybody has heard of them or has an opinion, they would be precluded, has an opinion and is not able to be fair, right? Not able to come in unbiased. They would be precluded. The judge nixed that and said, we'll let them know once they get here. Because they may have heard of it. And to the prosecutor's point, it's a fair thing. Like that was nationwide news more so than Charles Vallow, good, bad, or indifferent. And so people may have heard of that and not know her name specifically, but know her as the Doomsday Mom, right? And so once they make that Doomsday association, they may have a preconceived idea of her guilt. So missing discovery. So last time we talked about this, there was the Chandler police videos, and the judge basically already said it's not going to be admissible because it's hearsay, even though she's trying to use her dead daughter's words to help her. The prosecution made the point last time you don't get to kill your witnesses and then also have their testimony. So prosecution said they couldn't find this Chandler, Arizona video that Lori claims to have been shown by her mitigator. Now, I've seen the video, so I know it exists, but I'm with the prosecutor. Like, why am I spending all this time on this? It's not going to be admissible anyway. Lori is very pedantic. It's her right, and they're withholding it from her. And the prosecutor's like, we are not withholding it because we don't know what you're talking about. So when the judge kind of queried Lori and was like, did you see the video or did you just hear about it? And she's like, no, my mitigator showed me. And so then the judge says, well, why can't you just ask the mitigator to send you a link to that? And then that opened up a whole other can of worms because apparently her prior team is not talking to her, not a one of them. And she's alleging they haven't turned over anything except for the terabytes. They haven't turned over any of their work product, right? So whatever the state gave them, they've passed on to Lori, her advisory council. I want to make that point too, because I couldn't remember the name and everyone's like, it's standby council. It's not, because I was like, no, she's too interactive to be standby council. She's advisory council. So they haven't given the advisory council, the investigator, or Lori any of their work product. I didn't know you had to do that, but apparently that you do, and the judge is going to set an order for that. So hopefully she'll get that link to give to the prosecutor so the prosecutor can give it to her, or they'll record it and give it to her. So I don't know. Again, it's just one of those. It's my right because we already know it's not going to be admissible. There's a video that I've seen of Lori. There's one with Lori and Tylee in the two chairs together. Then there's one with Tylee in the chair, and then there's one with, I believe it's Alex. I might be mixing it up. I know they did one at the house. Either way, they've not given any of the footage from inside the interrogation room. What they gave her was body-worn camera. She wants the videos that she saw through her mitigator. Pedantic. Girl, you got a lot to worry about. You got a long way to go and a short time to get there. And we are going to talk about that because remember last time we talked about her and this speedy trial business, and she was trying to like one up the state and say, well, they could do them both at the same time. And then the state was like, listen, lady, do you really want to be in front of the same jury accused of murder and attempted murder? So, yeah. The witness list, so they're adding in late witnesses. The judge made the point the cutoff is done for witnesses, for evidence to be entered, like whatever that 30-day ramp is, because we're meant to start picking the jury on March 31st, and we are at March 19th as I speak to you. And so the state is being gracious and saying, listen, we'll go through there. They gave us addresses. They didn't give us phone numbers. The investigator saying he hasn't had time to get the phone numbers, but the state basically asked for leave to reject any of these witnesses if they don't get to interview them or if they don't get their information to be able to even contact them to interview them. Lori was like, the state has already interviewed these people. And then the judge clarified, do you mean the state or do you mean the police? And then she was like, oh, the police. Do you know? So it's like they still have the right to interview them. And the prosecutor made that point. You'll see when we get there. The other thing, they want her phone, which is also like giving me throwback of Sarah Boone. I'm convinced that Lori watched Sarah's trial. I don't know how. I'm just convinced. There's too many things that she's picking up that Sarah Boone put down. And so it's a lot. It's a lot going on. No, I lost my train of thought. Speedy trial. Oh, the telephone. So she wants the actual physical phone. Her investigator wants a physical phone. The state is saying, ma'am, we gave that to you in this large terabyte file. And then the judge went to the investigator and he's like stumbling and bumbling. He's like, well, if I give that to them, that's the only one I have. And he's like, why can't you make a copy? And then the guy's like, it's a very large file. Why don't you just copy the part that you need and give that off to it's basically like a digital forensic analyst is what I'm getting. Like they're going to do their own Cellbrite or whatever on Charles's phone, which Lori calls her husband's phone. Freudian slip. Girl, don't be claiming him. That makes it worse that you murdered your husband. But yeah, so it was an interesting exchange and we'll look at it. But basically, it seemed like the investigator was confused that he could copy from the terabytes because I know it can't be like a money issue. Boy, if you don't go down there and get you a scan disk and save that right on that scan disk and send that over to that forensic guy, but they want the physical phone. And so the state went into this thing of like, we don't normally give out the phone. But if we do, you're going to have to sign a waiver saying that you understand once this chain of custody is broken, we cannot guarantee the validity of the data. And so the judge piped in and was like, well, wait a minute. So he hasn't even started the extraction yet. He hasn't looked at any of the data that you have on the terabytes. You're running out of time, ma'am. You're supposed to turn in a report. And technically, it's too late to even submit that report. Do you want to push your trial date? And she was like, no, she's going on her, I have the right to a speedy trial. Why, ma'am? You're doing life. You're not going anywhere. And so they kind of had this back and forth on multiple points of like, you kind of have to pick which path you want. Either you want all this information in and on the record, you need more time, or you want the speedy trial, which means some of this is not coming in, right? So focus in on what it is that you want and what you're trying to prove, how you're going to present your case. She's only going to get one bite at the apple. So she's stuck on the March 31st. I mean, common sense just dictates that she take more time to get all the things, like all her ducks in a row, as they say, but she didn't want any part of it. So we'll see. Investigator is also giving me Billy Lane vibes with her. Like she kind of scooched a little closer to him where she had been sitting closer to her advisory council. You guys let me know. I don't know. Maybe I'm reading too much into it. You let me know what you think when we watch it. Also, the cameraman was zooming in on her foot again. Nice nude sock she had on, I'll say, by the way. But what is with the foot? I know you guys are like, he wants to see if she's nervous or how it was still this time. So she got the memo. And she's not moving that foot, but I just thought it was interesting. I think that's it. They're gonna come back next week. I can't remember. We'll watch it. I can't remember if it's in person or if it's just the state filing, like she couldn't get a hold of these witnesses, or she is not accepting or wants to object to specific witnesses. I'm curious as to who is on these witness lists. And Lori got a little saucy, like they should have their contact. They contacted them, and again, it was the PD and not the state's attorney's office. All right, let's get into this. Let me make myself somewhere small and make this a little bit bigger. I'm going to put this on I'm going to put it on 1.5x. I will turn the subtitles on. If it is too fast for you, feel free, just hit this. You see this right here? This little control button. You can do it on your TV with your remote. Here's the playback speed. I'm going to do 1.5 because our judge talks a little slow. If that sounds too fast for my ear, I will slow it down. But again, you feel free to play it how you see fit.
Pretrial publicity or opinions people may have had or exposure to the case people may have had. And then it has the questions where we may lose additional jurors on the trial schedule, and then victims of crime, views about police officer, and then if they've been charged or a close family member has been charged with a criminal offense, and to explain that. Any comments from the state?
Judge, in terms of publicity, I think my concern would be that when the jurors come in here and start hearing about the case or hearing testimony about the case, they'll hear the names Tylee and JJ, which obviously there was more publicity about those than about Charles Vallow. And so I think if we really want to ensure that the jury is unbiased and has had no pretrial publicity with regards to the defendant, we're going to have to question them as to their knowledge of her other convictions out of Idaho. That was something that was just incredibly all over the media.
I agree, but I think that may happen in individual voir dire. This initial questionnaire, if they recognize the name Vallow or Daybell and they've been exposed to something in the media about it, they should tell us about what they know about it and about whether they know about that other case and whether they know about anything that happened to it about it. So I anticipate losing a number of jurors just based on that. But I agree with you. Some may say they've been exposed to it, but it wouldn't affect their ability to be fair. And in individual voir dire, we can explore those options. I don't want to necessarily.
That is a key point, and I think sometimes that gets lost. Just because they've heard about it does not automatically preclude them from serving on the jury, right? But if they're like you and I and they've formed an opinion, like, yes, that bitch did it, then that precludes them. Or they can't go into it with an open mind because they've seen so much about the case. So I just want to make sure that I underscore that distinction.
Necessarily taint the whole pool by saying, hey, she's got these convictions in this other state.
And Your Honor, I don't propose we talk about the convictions, but we will hear the names JJ and Tylee in this trial. So that's my concern, is if we don't raise those names, whether we put them in the list as people that they may hear.
What I could do is on question 15, where it lists out my name, court staff, I need to include your name, the attorney's names, the advisory council's names in there. I'll add those. But at the bottom where it says other potential witnesses, I could do a third or another category that says other people that may be referenced but are not going to testify and list those names. That's fine. Is there any in addition to those two?
That would be the only for that. I think the other issue is, of course, the defendant's supplemental 15.2 names.
When was that filed? I haven't seen it.
I filed actually 2 motions to preclude them all and emailed them to your court Sunday.
Okay, maybe that's in my folder. That's on my desk.
Defense filed that on the 12th of March.
Okay, before we get to that, let me ask the defendant. Other comments on the proposed questionnaire and the information that we're going to put in there?
I think it's
okay.
What's that?
Pretty clear.
Okay, do you have any objection to listing Tylee and JJ because they will be mentioned?
No.
Okay. All right, let's take a look here.
So just so we're all on the same page, they're going to add Tylee and JJ for the names. He's talking about a third category. So this is going to prospective jurors to understand like what their knowledge of, and if they indicate that they have heard of Tylee and JJ, that will be explored further during voir dire.
Let me ask the state, you have 21 witnesses listed. I need to look at the defense witnesses that were listed. And we're after jury selection. I recognize jury selection could take longer than the initial week that I've set forth, but from April 7th to May 15th, the current screening, that is 20 full days of trial and 2 half days. So essentially 21 days of trial. Do you really think we need to screen that far out? I know you're being overly cautious.
I think, especially given that I'm not positive we'll pick a jury in that first week, I think we should, Your Honor.
All right. Defense have any comment on how we're screened through May 15th?
I think it's plenty of time, Your Honor, myself.
Says she with 0 trial attorney experience.
All right, let's deal with a couple things. First, I've received a notice of compliance. That was when the defendant requested the Gilbert video. Is that apply to the second case or this case?
Your Honor, it's an incident that occurred in January. It's not really, it was disclosed because it is mentioned in the DR. The defense had filed a motion for the state to disclose that, and then had brought up again on the 11th that the state had not disclosed it, that there was some YouTube video of that. I have looked for said YouTube video. I have gone through the police report. I don't know what video she's discussing, but we're not aware of any video that hasn't been disclosed. So
I think that's weird that she went to YouTube to look for it. Why not call the Chandler police and say, hey, we need your interrogation footage? Do you know what I mean? Like in the Sarah Boone case, I just requested it. They knew what I meant. It seems weird that she's searching YouTube. That's what I'm saying. Sometimes I feel like she's going tit for tat. I want her to rise above it. I mean, listen, y'all know I attend Petty University, but come on. Represent the people better. Be the better part of ourselves, ma'am.
providing notice that disclosure is complete as to that police report that is peripherally relevant.
All right. Any comment on that?
Yes, Your Honor. For clarity, is the state proposing that there is no video or that they don't have to give it to me because it's not attached to that DR number?
I think what she said was she's not aware of what video you referenced. So as far as her knowledge, she doesn't have it and doesn't know about it.
So I should go directly to Gilbert Police Department to get it?
Well,
Sure.
last time you were in court, you said your investigator or someone told you about it,
A mitigator.
a mitigator.
Showed it to me.
If they have that link, why don't they just send it to the state, and that may help the state determine if that's something they've already disclosed?
I will tell you why they won't, because that is my former team and they will not do anything to help my investigator, my paralegal. They won't give us any information that they found. They won't talk to us at all because apparently there was a conflict. So they will not help us. They will not send us anything. They will not email us anything. They will not answer anything that we ask them to. So that has been the response from my former defense team. That's where we are.
All right.
Well, all right.
Do you know, and maybe your advisory councils can speak to this, did they turn over a file to you or did you have to start from scratch?
No, from what I understand, all they turned over was the 22 terabyte hard drive, and that is it. They didn't turn down any notes, any work product, nothing that they had done to that point. Continue to stand by that today, even though a lot of that information I gave to them.
22 terabytes is a lot of data. I'm imagining some of it is video, but what do you guys think is on there? Like, I would say probably the body cam footage of Charles when he was like saying his wife thinks he's Ned or whatever that was. The body worn camera at the scene when Lori's like, oh, I'm having a barbecue later. Hi, neighbors. We just moved in. But what else? Like, couldn't, oh, I do have I think I have his ME report. If I have it, I'll make a separate video. But yeah, like the autopsy report for Charles. But this is insane. That's an insane amount of data.
They would not give it back to me.
Her advisory council looks like she wants to crawl under the table.
All right, I'm gonna make an order and it'll be in the minute entry that they turn over a copy of their entire file, including any mitigation information that was gathered to the advisory council to makes Hicks, you look like you want to say something.
I don't know.
Where's she going? Sidebar? No, because state is there. So he's ordering them to turn over everything, work product included. So whatever mitigating things, things that might be exculpatory for her. Yeah, and anything that she gave them. So he's gonna create an order and give that to the former defense. I'm curious as if they'll come back and say,
All right, so I'll do a more detailed order about, they should have turned over a copy of their entire file to advisory council when they withdrew.
if they'll raise the conflict with the judge. I'm surprised she didn't raise this earlier. Like, fighting for all her rights, girl. Don't you have a right to your staff? Especially pressing that March 31st deadline button. Boop, boop, boop. Okay, let's scoot along until we see somebody's mouth moving here. Do you guys think the judge has on Argyle socks? He's giving like Leave It to Beaver, Daddy-O. Maybe Eddie Haskell's dad. He seems a little more hip than Daddy Cleaver. Okay.
Response from the defense.
Let's see.
Well, let me start. Have you received any response from the defense, anyone from the defense team since you filed this on March 16th?
Your Honor, last night at 10:30 or so, defendant's investigator sent over a list of the addresses of the witnesses. I did speak with him this morning. I still am unclear if defense will be setting up those interviews or if they will be providing phone numbers to the state to set them up ourselves. As for the expert, again, last night at like 10:30 at night, defense investigator emailed the state and indicated that the defense expert would need to or wanted to obtain the physical laptops and cell phones that the police had impounded so that he could then review them, do his own Cellbrite or extractions. So obviously the expert hasn't even begun work, let alone they've also requested all impounded items from law enforcement. I'm unclear if they're asking for ones that were impounded in Idaho as part of their investigation or just the ones here. The statements from the investigator appears to be all of them, which would mean the state would have to request Idaho to send those to the investigator. So again, given all of those issues, I don't see how that it would be possible for the state to provide that to the expert prior to this trial beginning, let alone to get a report or an opinion prior to this trial beginning.
All right, let's set aside Dworkin for the time being. So well, let me ask the investigator. What's your name, sir?
Jeff.
Jeff what?
White.
Okay, Mr. White, are you going to be setting up interviews for the state to interview whatever potential witnesses the defendants noticed?
I'm trying to verify, excuse me, sir. I'm trying to verify the phone numbers to be correct. I do have a few of them, but some of them I'm trying to make sure that these are the correct numbers.
Okay.
I did the searches for them, and I have to apologize. I left yesterday, and
How many witnesses could that be? If little old me sitting in my bedroom can find phone numbers for witnesses in Sarah Boone and other cases, the Gardner Bradigan case, sir, you're an investigator? What, you should have been up all night getting these numbers. Like, what do you guys think? Because the state has 21 witnesses, but that's going to be like the forensics, that's going to be the medical examiner, crime scene investigator, detectives, right? So that gets up quickly. But who the hell is Lori calling? That is, they can't just get the numbers in one night.
for some odd reason, my email just did not go through. So,
Your Honor, my understanding is that the state has interviewed every single person on my witness list previously. That's where I got the people from the interviews that they had from the state previously. So I understand that they're allowed to do another interview of them, but they have interviews of every single person that is on my list with the exception of one.
Which is who?
which is Nate Eaton.
And
When you
Jared.
say the state's done the interview,
Nate is part of the
police or
story.
someone from the prosecutor's office.
In discovery, I have interviews with police on every single one of the witnesses that are on my list.
Okay.
So I know that they had their addresses. I know that we were trying to get the addresses to them in the
Sorry, because I talked over that. So that is the distinction, right? Just because the PD interviewed them does not mean that the state then interviewed them. She's going through her discovery, like when we went through Boone's discovery, and it's like this statement, this state, what happened. They put the information there. But how many years ago was this too? I mean, still have the same number, at least since 2014, when I switched from my 310 LA number to a New York number. But it could have changed. Do you know what I'm saying? I think, yeah, it's to say the state already has that is just her arrogance. She's loud and wrong.
quickest way possible. And where I am at the jail, the communication is very I know that we were trying to get the addresses to them in the quickest way possible. And where I am at the jail, the communication is very difficult for me to get a hold of my investigator, to get a hold of my paralegal. I'm 23 hours a day locked down. If I don't have Wi-Fi, I don't have a phone. If I don't have battery, I don't have a phone.
You know how you fix that? Don't do crimes. Or keep your defense attorney, ma'am. We're out of tiny violins for criminals this week.
I don't have access to get to people. So I understand the time constraints, and we're doing the best that we can of getting things answered, getting things put together.
So as a threshold question, your assertion is that all these people that you've listed in your notices have relevant information for trial?
Correct.
And do you know if the police have interviewed these
Well,
people?
Your Honor, the
They may be
first
referenced.
listed person is a reporter. So I'm not really sure the relevance of a reporter.
He's the only one that hasn't been. So that's what I stated.
So, Your Honor, the point is to start with, one, these people, I'm not sure all of them actually have been interviewed. Those that have would have been interviewed 5 years ago. So whether or not their addresses are correct, unclear. It's not the state's responsibility or the defendant to do the defendant's work and find these people. I have an absolute right to do interviews just as the defendant does. So in terms of the witnesses, I think that most of them, as best I can guess, would be character evidence, which would be improper under 405. So depending on what they say, then I need to file motions to preclude or motions in limine for any or all of these witnesses.
All right, so it's premature to address these today. The state's going to have to interview them and find out if, in their opinion, they have relevant information or not. And then if there's a dispute as to whether or not they'd be called, I'll have to deal with that as it comes up. But if they're unable to be located or interviewed, obviously they won't be called at trial. Mr. Dworkin, if you want him to do extractions, you're not ready for trial. So in order for him to do the work that he's requesting, getting copies of a laptop or a cell phone or whatever the case may be, that's going to take him time to extract and analyze and then prepare a report, months maybe.
I understand that, Your Honor, and I'm hoping he can do it in an expedited manner. I requested him from OPDS on January 14th. He got approved on March 7th
Well,
from OPDS.
you're the one pressing for your speedy trial, so you kind of have to make a decision on, we're set for trial. You want to go to trial or you want to have him do that work that you want? Because I don't think both are going to happen. Even if you got the laptops today, generally those types of things can take weeks, even months to analyze and prepare a report on.
I understand that. And I also understand that I've only been given 10 hours for him from OPDS, right? So if he could spend 10 hours this week getting them ready, then he can give us a report with the best that he can do.
Well, the report's already late technically, but if it were allowed, first of all, it's going to take time to coordinate him getting let's start here. Specifically, what are you requesting? Because the state wasn't clear whether you were requesting items here impounded by a particular police department or items that may be impounded in Idaho.
Well, I'm sure that my investigator would like to have all of those things done, and I realize that we're on a time constraint, and I would be only concerned with one item, which is at Chandler Police Department, which was Charles, my husband's phone, Charles Vallo's phone. And I would like a copy of the extraction that they took from it. The digital forensic extraction from Chandler Police could be given to him immediately. That would be very helpful.
Wasn't that already disclosed?
Yes, Your Honor.
Was that part of the initial terabyte?
Yes.
Excuse me.
Yeah.
Everything that I have is on the 22 terabyte. So if
Hard
I,
drive.
hard drive, so if I give that away, I can't do my work.
Well, can't you make copies of files out of it?
22 terabytes.
I understand that.
Okay.
So what's your proposal?
I'll take it up.
I mean, if you have all that information in a file, I'm not saying you have to copy the whole 22 terabytes, but there's a file in there somewhere that's the Cellbrite extraction already for that requested item that's been in defense possession for however long now.
I'll take it up tomorrow.
So I'm happy to make an order, but again, if he's not done with that information you want, are you still wanting to proceed to trial at the end of this month?
Yes, Your Honor.
Okay.
Do you know what's really fun? Making a website on Wix.
Hey, we're How Ridiculous, three childhood friends.
Well,
would
it
put
could
this-
still be precluded because depending on what his opinion is, first of all, it's late under the rules of evidence and rules of disclosure. And secondly, depending on what he says, the state would have to have an opportunity to consult with an expert as well. So even if he got something done, it could still be precluded, but I'll give him the opportunity to do whatever it is that you think he needs to do to analyze that. But that information's been in defense possession for months, if not over a year.
More than a year, Your Honor.
And he was just approved by OPDS last week, Your Honor.
I thought you said he was approved.
Even if it was last week, honey, you were missing some days because we're in the next week and your investigator hasn't figured out how to copy the relevant pertinent files onto a scan disk.
You applied in January.
I applied for him in January and last Friday, he got approved.
Again, this is one of those things where you have to weigh your options on whether it's worth it to get a continuance so you can have your defense do the work that you want done on your defense. But if you're telling me you don't want to do that,
I would like to do that, but my situation in my housing department precludes me from doing that.
from asking for a continuance,
No, from getting things done in an effective and quick manner.
all right, well.
So
you're telling me you
knowing
don't want a
that-
continuance, because any information he has at this point could be precluded as being untimely.
I understand that is the rule, and I understand how unfair and prejudicial that would be to me.
Do you understand that you're prejudicing yourself by demanding that these things happen? You're the one who chose to represent yourself. You knew you were locked down 23 hours. Pick a side. Look alive.
So I guess I'm gonna have to cross the bridge on whether these notice defense witnesses are even able to be located and interviewed before I make a decision on whether they have relevant information and can be called at trial.
Obviously, Your Honor, we have a little over a week to try to interview these people, so
I
I will
understand.
file something at the end of next week indicating who I've been able to reach and interview and ask to preclude everyone else.
All right.
They also obviously ask to preclude them regardless,
Right.
based upon what they may say.
All right. What else do we need to address today then? From
Your Honor,
this-
the only other motion that we did not address last week was the state 609 motion. I presume the defendant will likely testify, so I didn't know if we wanted to address that now.
Are you prepared to address that now?
No.
I generally will, I guess I'll advise the defendant now that if you choose to testify, it's likely that the jury would hear about the convictions. But at your request, they could be sanitized, meaning that they would only hear about the fact that you have convictions, as opposed to what the nature of the conviction are. But that would be up to you, whether you want that information out or not. And then the jury would receive a limiting instruction that the existence of those convictions is only to be used for the purposes of determining credibility. So you should be aware of that when you make a decision on whether you want to testify or not. Oh, if you do want to testify, it will be question and answer, meaning you need to write out all your questions that you want to be asked and have one of your advisory counsels ask those questions to you.
Oh, I'm glad we did watch this. I forgot that. I skipped it in my notes. But yes, no narrative. You won't be doing any Robert Tejas business. We need questions, man.
When you're on the witness stand.
Right.
Okay, so you can't take the witness stand and just give a narrative, it'll be question and answer.
So am I supposed to reply to the 609? Is that what you're saying? And
well-
for it to be sanitized if I want that?
We can talk about that when we actually have a 609 hearing, but yeah, you can make that request orally. You don't have to do a written response. I indicated last time for your opening statement and closing argument and questioning witnesses that you'll pretty much be limited to the podium.
Mhm.
We'll be in a different courtroom apparently for trial, but it'll be set up very similarly. Either your investigator or one of your advisory councils will approach witnesses with exhibits if you have to show a witness an exhibit. So I'll have to do the same limitations on the state. The state would be confined pretty much to the area of the podium, and the state would have someone assist in approaching witnesses with exhibits and that sort of thing.
So we've seen that before with pro se defendants, most notably Daryl Brooks. They keep it even so they're not, so it doesn't look odd, right? Like, why does it could imply guilt, like, or indicate that her movements are restricted. So to eliminate that sort of suspicion, I guess they just keep it equal.
All right.
I have some motions that I'd like to file. I've had a really hard time getting my
copies
paralegals
for the
very
state?
busy. I don't have copies.
All right, we'll make copies and give them to the state, and then we'll file them, and depending on what they are, I'll rule on them as the response and replies come in, or we may have to address them depending on what they are. So plan on that questionnaire going out. I think we said next Thursday, the 20th, will be sent out to potential jurors for the first batch of jurors, and then the responses would be cut off on the 26th.
Judge is going to be sent out Monday the 24th and will end on Monday the 27th.
All right. And then I'll meet with the parties on the 31st to go over those remote responses.
That's Izzy coming in over here. Also, that dinging is the Zoom as people come and go. It's not on my side.
So that'll be the 31st at 10:38. Then again, I'll just reiterate on April 1. Are we having we're not having walk-ins, Izzy, until the 1st?
Correct.
Okay, and then on the 1st, we will meet again, and for the rest of that week, we'll likely be meeting at 10:30 and continuing with jury selection every day until we get enough jurors. Hopefully we get enough the first week. If we have to, we'll go into the second week.
Going to put out there, since I obviously don't know when we will get the jury picked. I do have some witnesses that are flying in, so I may have some days where I may need to end a little early or whatnot to try to accommodate some witness schedules. But I'll keep the court updated once we get a jury picked.
I think we'll have a good idea by about day 2 of jury selection, whether we're going to need to go into the next week or not. That reminds me though, is I would like the parties to plan on, we're going to have a much better idea after about the second week of trial and the first trial, how the second trial will unfold as far as how many jurors we might need. But I would like the parties to plan on doing another remote questionnaire with a much larger pool for the second trial and meeting on Friday, May 30th. I'm just giving you a heads up as far as this is concerned. And then for scheduling purposes, so everyone knows, I'm planning on probably going Monday through Friday of the week of June 2nd, as well as Monday through Friday the week of June 9th, to try to get as much done as we can. And then there's going to be some dark days there toward the end of June, but we need to get it done by July 4th.
Your Honor, when are you planning on starting that trial?
So jury selection would be starting May 30th. All right, anything else from the state?
So he previously said in the last one that he has some unavailability in June. So when they're starting on May 31st, does that mean he's going to do it? He never clarified if he spoke to the chief judge. But I'm guessing he did since they got the bigger courtroom. So we're gonna infer, but it's not confirmed.
For today. If you want to stick around, we'll get you copies of those motions.
I do. Your Honor, I guess the only other thing is for the questionnaire, are we going to put in the defendant's 15.2 witness list?
I'll put in those names preliminarily. It doesn't hurt, just in case anyone is called from that list. And if anyone knows any of those people, I will put that in actually. Anything else from the defense?
So I'm unclear on where we stand with the video that I requested.
The state says they don't know what video you're talking about. They've disclosed everything they have. So I'm going to make an order to your prior team to give you whatever that is. If you have a link in that information, you can forward it to the state so the state can see if that's something they've already disclosed or if that's something Gilbert didn't give them, or on the other hand, since it was told you secondhand or showed you secondhand, whether it's something different than what you thought it was. I don't know. So I'll make an order that they hand over all those things to you, so maybe you can figure that out. But at this point, the state says they've disclosed everything that they have and everything that they're aware of.
And in that order, they'll give it to my advisory council, or
Who do you want me to? I was going to say give it to your advisory council. Do you want a more narrowed order? Maybe any mitigation work that was collected, or do you want a broad order that's basically everything in their possession?
Well, it would be nice if they could turn over everything in their possession that we worked on.
I was just thinking
sure.
it would be easier for you maybe to find that needle in a haystack if it was a more narrow order.
Well, she knows what the link is, and she could just give it to us, and we asked for her to do that, and
What's that?
the attorney said, no, she can't do that. She can't give you anything.
What's that mitigator's name?
My mitigator's name? Pamela.
On your prior.
Pamela Kearney.
Do you know how do you spell Kearney?
Cerny.
What other mitigator would he be asking for? But again, she's being pedantic because he already said she can't use Tylee's testimony. She can't use the video as testimony in this trial. So it's more of like, they didn't give it to me. And when he's saying, do you want me to narrow it so they are not giving, everything in the kitchen sink? Well, it would be nice if they could give it all to me. Again, she's already short on time. Pick a side. Look alive.
All right, I'll make a specific reference to that.
And do we need an order, Your Honor, to pick up my husband's phone at Chandler Police so that Lonnie can do the extraction?
Well, you already have that extraction in your discovery. What's the state's position on Lonnie Dworkin meeting someone at, you said Chandler, right? Chandler
Yes, at
Police
Chandler
Department
Police
to do another extraction.
Your Honor, obviously the
Wasting
state
time.
and defense have always had stipulations so that should something happen to the device while it's in the possession of Mr. Dworkin, that there are now no issues with chain of custody or anything else. So the state would have to draw up a release, have that scheduled on who it's going to be picking it up, have the defendant sign that release indicating that she understands that should anything happen to that she waives those rights to claim those things. So
I think what I was asking was, does Mr. Dworkin have the ability to just do the extraction on site?
on site where? At Chandler?
At Chandler.
I don't think the police departments allow anyone to go in there and conduct their work in the police department.
Okay.
Should we find out?
So to maintain the chain of custody, the state can draw up an agreement, and if the defendant signs that agreement, then Mr. Dworkin could pick up that phone.
That's perfect. Logistically, how's that going to happen?
She's going to forward that to your investigator, and I guess he'll have to come down and have you sign it.
Okay.
All right. Be recess.
All righty. Okay, without me prompting during the middle of it, did you guys think she was scooting closer, closer, and closer to her investigator? I thought it was interesting. She's gonna cut off her nose to spite her face, right? What is that other expression? You can't see the forest for the trees, or whatever it is. Like, she's just wasting time. Ma'am, the clock is ticking. You're demanding that the clock continue clicking louder and louder, but you're throwing obstacles in your own way. So what do you guys think? We'll keep an eye on this. Yes. She's got her hair done. She's got her highlights. I don't know if that's that prison life. I know once Sarah got to prison that she ordered up, what do we say? Some mauve. She ordered up a few things, whatever we said in the last video, cosmetics wise. So I think over there you get like dye and whatnot. And we know Lori was a beautician because she's got some nice coloring going on. Do you know what I mean? Highlights, lowlights. For a prison gal, she's looking all right. Yeah, so we'll keep an eye on it. I'll talk to you guys later. Looking forward to talking to you in the comments. Toodles!